discussion, we were taking up fundamental rights, and in fundamental rights we had yesterday discussed, the last part of our discussion was Article 23 and Article 24 of the Constitution. Article 23 of the Constitution deals with involuntary labor. I have given you certain examples here also. One of those examples that we did talk about was the Indian Police Act 1861. To be very specific, Section 17 of the Indian Police Act 1861 deals with the same provision, that any individual who has who is of the rank of inspector or above can appoint an individual as, or can force an individual to provide involuntary labor. Now, Article 24 of the Constitution dealt with child labor. Now, Article 24 of the Constitution dealt with child labor. To be very specific, it says, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any hazardous employment. This is what Article 24 says. If we go back to our yesterday's discussion, we had also seen that there was a law that was enacted in the year 1986, and the law specifically deals with Child Labor Prohibition and Regulation Act 1986. Before that, there was a case, a very important case that happened in the year, it happened in the year 1982. In the year 1982, the case is famously called as the Asiad Workers case. So, Asian Games were held in India, 1982 in fact, with the introduction of color television in India, 1982, because of Asiad Games that happened. So, in this particular game, when this game was being conducted, and the labor that was required for building the necessary infrastructure, in that particular case, the Supreme Court had said that Article 24 of the Constitution does not require a law to prohibit child labor, because if you see the provisions of Article 24, Article 24 explicitly says what? Article 24 of the Constitution explicitly says that there will be any individual, any child below the age of 14 years will not be employed in any kind of factory or mine or any kind of hazardous industry. It talks about a hazardous industry. But what it does not talk about is what will be the punishment prescribed. That means if there is employment of children below the age of 14 years or up to the age of 14 years, even in hazardous industries, Article 24 of the Constitution does not provide what will be the penal consequences of it, what will be the penal provisions. That is not something that has been mentioned. So, Article 24 of the Constitution, before the Asiad Worker case, it was considered that Article 24 can be implemented, or such prohibition can be done only when there is a legislation, an appropriate legislation enacted for this very purpose. There is no need for an appropriate legislation to have a penal consequence, which means that even before the 1986 law, even then if an individual employed children below the age of 14 years in any kind of hazardous industry, it would still be considered to be a violation and hence will have some penal consequences attached to it. And hence it will have some penal consequences attached with it. Clear? So it was declared as proprio vigor. Interestingly, in almost similar, similar year, there was a case in which, the case was famously called as MC Mehta versus the state of Tamil Nadu case in 1990. It happened in the 1990s, this particular case, And in this case, the Supreme Court banned use of child labor in the Shivkashi factories, firecracker factories that are there located in Shivkashi. It was banned. Not only did that happen, the Supreme Court for the first time also came up with certain directions. It issued directions with respect to how should this ban be implemented. And in this case, the Supreme Court ordered for creation of a fund to rehabilitate the child labor who were involved there, and also those children who were involved, their family members, their adult family members or members above the age of 14 years, they were given employment in place of the children who were employed in Shivkashi, and there was a fund that was created for education and rehabilitation of the child labor. It was one of the first cases, it was initially, there were a number of such cases, but it was one of those cases in which the Supreme Court, the Supreme Court gave directions as to how to implement such a provision. That means, child labor, whenever we talk about child labor, we tend to consider that child labor is prevalent in India because obviously the poverty and the population that is there. And in this case, households wherein households do what, they employ children or they allow their children to work so that it would act as an additional hands which could earn employment because they are poor. So in this looking at this very case in this manner, the Supreme Court declared that there should be a fund created by all these factories who have previously employed children. They should create a fund. That fund should be utilized for the rehabilitation of the child labor, allowing them to, for education, etc., etc. And also ensuring, it was not just about education, it was also ensuring that they were substituted, the child labor that was there, it was substituted by individuals of the same family who were above the age of, who were 15 or above the age of 15 years. Clear? With this, we complete our discussion on Article 24 of the Constitution. Thereby, we have also completed the fundamental right against exploitation, the right against exploitation that we have. If you remember, we had also said that right against exploitation is available to us not just against the state but also against individuals. Otherwise, if you look at fundamental rights are generally available to us against the state. But nature of this fundamental right is such that it is not just available to us against the state, it is also available to us against other individuals. So no one can employ children. It's not that only the state cannot employ children, no one can employ children. So if you look at till today, all those fundamental rights that we have discussed, if explicitly talking about what are the fundamental rights that are available to us not just against the state but also against individuals, we have discussed Article 15 Clause 2. Article 15 Clause 2 talks about access to public places. If you remember, when I asked you what is the difference between Article 15 Clause 1 and Article 15 Clause 2, you said that Article 15 Clause 1 was against the state, whereas Article 15 Clause 2 talks about not just against the state but also against individuals. Similarly, we did discuss Article 17 of the Constitution, which talks about prohibition of untouchability, and it is not just that the state cannot practice untouchability, we as citizens and individuals or any organization can also not practice untouchability. So Article 15 Clause 2, Article 17, Article 23 and Article 24. These are those articles that are available to us, those fundamental rights that are available to us, not just against the state, but it is also available to us against other citizens. Clear? Clear? Next, Article 25. Article 15 Clause 2. Article 17, Article 23, Article 24. Available to us not against the state but also against the citizens. 15 clause 2, 17, 23 and 24. Let's start with the next fundamental right, that is right to freedom of religion. First article, Article 25 of the Constitution. Article 25 of the Constitution. Write down, what does Article 25 say? Subject to public order, morality and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience, and the right freely to profess, practice and propagate religion of one's choice. So if you look at Article 25 clause 1, Article 25 clause 1 gives us the right. What are those rights that are conferred to us under Article 25 clause 1? Article 25 clause 1, the right that is conferred to us is first, right to conscience. Second, the right to profess, practice and propagate, which means if you break these rights into classifications, you would find that we have 4 rights that are given to us under Article 25 of the Constitution. And it says, Article 25 clause 1 says that we have the right to conscience of a religion, we have the right to conscience of any religion of our own choice, not the religion that we are born into, the religion of our own choice. Profess, practice and propagate a religion of one's choice. Clear? Now, Article 25 clause 2 is basically exceptions to Article 25 clause 1. So what is Article 25 clause 2? Write down before I start our discussion on it. Nothing in this article shall affect the operation of any existing laws or prevent the state from making any law regulating or restricting any economic, financial, political or other secular activities which may be associated with religious practice, and for providing social welfare and reforms or throwing open of any religious institution of public character, to all classes and sections of Hindus, throwing open of Hindu religious institutions. Clear? So Article 15 clause 2 talks about what? Article 15 clause 2 talks about exceptions. No, Article 15 clause 2 talks about 25 clause 2 talks about exceptions to Article 25 clause 1. Clear? Now let's understand this. First of all, if you look at how I have started dictating Article 25, it says subject to public order, morality and public health, and subject to other provisions of this part. Clear? What does this mean? Let's start with this. See, if we go back to our previous discussions, in fact the day we started our discussion on fundamental rights, we know that fundamental rights are not of absolute nature, which means they are subject to reasonable restrictions, and we have talked about reasonable restrictions as well. We have talked about reasonable restrictions under Article 19. We have talked about reasonable restrictions, contempt of court, anti-defection, all these things, defamation, etc. These were what? These were reasonable restrictions. So these are reasonable restrictions, and we from the very first day know that fundamental rights are not absolute rights, they are under reasonable restrictions. Now, if you closely scrutinize the wording of what Article 25 says, it says initially it mentions three criterias. What are those three criterias? The three criterias are health, morality as well as order. So public health, morality and public order, these three are what? Explicit reasonable restrictions that have been imposed on our right that we have under Article 25. I have not come to right, I am just explaining right now the reasonable restrictions that have been mentioned. Clear? The reasonable restrictions that have been mentioned. Clear? Public health, morality and public order. These three are explicit restrictions that have been mentioned. Subject to this, what do we have? Now we come to rights. What are the rights that we have? We have the right to conscience. We have the right to profess, practice and propagate. Clear? What is the right to conscience? What is the meaning of right to conscience? Right to conscience simply means that we as individuals, every citizen of India has the right to inward, whatever religious beliefs we have, whatever we think about a particular religion, we have the right to our inner understanding of those religious aspects, whatever is there, we have that inner right. And when that inner right takes an explicit or outward manifestation, it becomes a right to profess, practice and propagate. When we say the right to profess, the right to profess or the right to profession, what does that mean? It means we have the right to openly express our religious beliefs and faith. I can stand here and talk about my religious beliefs and faith, and no one, the state will not impose any restrictions on it, provided it is not hampering public order, it is not hampering public health, and it is not hampering morality. So in the name of professing or openly expressing my religious beliefs and faith, I cannot do what? I cannot disturb public order, I cannot disturb public health, and I cannot breach public morality. But otherwise, if I don't do that, that means if I am not breaching public health, morality or public order, in that case I have the right to openly talk about my religious beliefs and my faith. Whatever belief, faith I have the right to openly talk about it. Clear? Secondly, when we say the right to practice, what does that mean? The right to practice means that we have the right to practice rituals or ritual rights we have. So when it comes to the manner in which I follow rituals, the state is not going to interfere, obviously provided I do not hamper order, health and morality. Clear? And display signs and symbols. Practice means what? Display signs and symbols. So I have the right to display signs and symbols of my religion. I also have the right to do what? I also have the right to take up rituals, follow rituals. That is what is meant by practice. Third, propagate, which means I have the right to educate others. I have the right to educate others about my religious beliefs, faith and opinions. Whatever religious beliefs I have, my religious beliefs, I have that religious belief, whatever my religious beliefs are, I can educate you about those beliefs. No, I can educate you, you about those beliefs, about those rituals, about whatever, about my religion, whatever I think is necessary, I have the right to educate others. Clear? So if as an individual you are ready to listen, then in that case I have the right to educate you about my religion. Clear? So when we say right to profess means to openly and freely talk about my religious beliefs and faith. When I say the right to practice, which means I have the right to follow rituals and hold signs and symbols of my religion. And when I say propagate, it means I have the right to do what? I have the right to educate you about my religious beliefs and faiths. Clear? So if you look at the Article 25 of the Constitution, Article 25 of the Constitution does what? Article 25 of the Constitution gives us twofold rights. First is an inward right, that is right to conscience. And then there is an outward, when this conscience takes an outward form, it becomes right to profess, practice and propagate. So I have the right to talk about my religion openly and freely. Clear? So no one, when I am talking about my religion, no one is going to deprive me of that right. If I am not breaching morality, health and public order, that is obviously for a given. Secondly, I also have the right to practice my religion, which means rituals, signs, symbols, and I have the right to educate others. So if you look at right to conscience is an inward right. And when that inward right takes an external or outward format, it becomes right to profess, practice and propagate. And when we say the right to conscience, because it is an inward right to conscience is absolute. There is no what you don't write, just listen to me, बहुत ही important discussion है, ठीक है? There are lot of things that you need to understand here. Because it is my inward right. So when it comes to, because it becomes my inward right to conscience. Now right to conscience is not subject to morality. Conscience is not subject to morality. Conscience is not subject to public order. Conscience is not subject to public health. Until unless my conscience takes an external form. And when my conscience takes an external form, it becomes the right to profess, propagate and practice. So when I say right to conscience is an absolute right. The state does not interfere there. However, this right to conscience that I have, when it takes an external form, that is when it becomes the right to profess, practice and propagate, now that is what is subject to public health, morality and order. Clear? So the state can impose reasonable restrictions on it. The state can impose reasonable restrictions on it. Clear? Now, when I talk about these rights, now when I have the right to propagate my religion, which means I have the right to educate you about my religion, do I have the right to convert you? No. Any conversion that is there, it should be voluntary in nature. Now, do I have as an individual, do I have the right to choose my religion? Yes. And hence, I can voluntarily give up the religion that I am born into and convert into a religion, a religion which is something that is, that I am not originally born into. So, I will have the right to convert voluntarily, because I have the right to choose my religion of one's choice. Nowhere in the constitution it is mentioned religion that you are born into. No, religion of one's choice, which means you can choose any religion. Clear? Now, and the Supreme Court, when it comes to conversion, is very clear. There was a case in which the Supreme Court has specifically mentioned, the state of MP versus Reverend Father Stanlisius case was there, and in this case the Supreme Court has specifically said any conversion that is not voluntary is not, it is not to be accepted. Any conversion that is there, it should be voluntary. No one has the right to convert others. I have the right to choose my religion, but you do not enjoy the right to convert me. Clear? So any conversions that are there, it has to be voluntary in nature. Clear? Now, coming to some very important ideas that you generally tend to hear, and this is something that becomes very important. Now, when I say when I have the right to follow a religion, that means, and that is of my own choice. Suppose I am an individual who is born as a Hindu and I convert myself into another religion, like if I accept Islam. Now, because we do not have a universal civil code, we do not have that particular code. Now, can I indulge into polygamy? No. Why? Because when I say right to profess, practice and propagate religion, what we also need to understand is that when we talk about what is religion and what are the practices that I have the right to follow, what are the religious beliefs and faiths that I have the right to openly talk about, and what is the religious what is the kind of education that I take up of any other individual on my religious beliefs and opinions, it is subjected to something called as something that is internal, or all those rights or anything that comprise of a religion, and something that is absolutely necessary to follow in a religion. And certain practices, though it is being taken up, though it is done, but it is not considered to be a matter of religion. Like when we talk about polygamy, though polygamy is allowed in a particular religion, but it is not considered to be something that is a matter of religion. Why? Because can we say that polygamy is an integral part of a particular religion? No. Polygamy is not an integral part of a religion. So whenever we talk about religious practices, very important, you should understand this. Whenever we talk about religious practices, what kind of religious practices? It is something, that is something that is to be seen. What kind of religious practices? So when we say religious practices, anything that we have the right to do is something that is a matter of religion. Anything that is not a matter of religion, we do not enjoy rights there. And when we say no, certain acts like polygamy, polygamy cannot be considered as a matter of religion. The Supreme Court has said this, that polygamy cannot be considered as a matter of religion. Even if I convert, I follow a religion, and according to Indian laws it is permitted there, but still it will not be, I can be prosecuted for polygamy even if I have converted. Why? Because it is a matter, it is something that is not integral to a religion. It is not something that is integral to a religion. We cannot say that Islam is defined by polygamy. We cannot say this. Anything that is a matter that is integral to a religion. And who decide what is integral to a religion? Court. It is the court which will decide what is a matter that is integral to a religion. Clear? Understood this idea? Now, coming to a very important aspect, just listen to me very carefully. Recently, the government came out with a law that made triple talaq a criminal offence. It was passed. Last session of the Lok Sabha, the law was passed. The last session of the Lok Sabha, the law was passed. Before that, if you go back to the last Lok Sabha, the last Lok Sabha also it was talked about, it was passed in the Lok Sabha, it was not passed in the Rajya Sabha. It was not passed in the Rajya Sabha. Before the Lok Sabha was dissolved, the Council of Ministers recommended the President to promulgate it as an ordinance, and triple talaq was promulgated as an ordinance. As soon as the new Lok Sabha met, after the formation of new Lok Sabha, it was passed as a law. So today, triple talaq is considered to be a criminal or a punishable offence. Clear? Now, if you look at certain MPs, even in this particular Lok Sabha, they were criticizing the law that was passed, this triple talaq and criminalization of triple talaq. A criticism was done, wherein they were saying that when it comes to religion, the state should not interfere with religion. And triple talaq is something that is a religious matter. Why? Because according to other religion, like if we talk about Hinduism, it is perceived that marriage is something that goes beyond one life. Marriage is something that goes beyond one life, whereas in Islam, marriage is considered to be a contract. It is not considered to be something that is more than one life, and it is considered to be a contract. Because it is considered to be a contract, what you should do is you should come out with laws which specifically makes triple talaq, incentivizes triple talaq, but it does not make triple talaq a criminal offence. It should not be made a criminal offence. It should de-incentivize it. That a law like, because there is in Islam, when a marriage is being taken up, so there is something called as this is there decided, something called as meher ki rakam, which means if in case of divorce, if there is divorce, in that case the groom is liable to pay how much to the bride. ये decide होता है. And he was of the opinion, while he was talking about this, so he was of the opinion that you can decide, you can make it 10 times, 100 times, but don't make it a criminal offense. Why? Because this is something that is particular to a religion, it relates to a religion, and hence the state has no right to interfere there. Clear? Understood this idea? I'll just describe this idea again, because I want the answer from you. Okay? Triple talaq is a criminal offense because there is a law that has been passed in India, and the law specifically says that any individual who takes up triple talaq in whatever form is to be punished under law, and there is a specific punishment that is prescribed. Okay? Now, in the criticism of this particular law, one of the MPs in the parliament, he said that because marriage in Islam is a contract, marriage in Islam is a contract, because of this, what you should do is, because it is something that relates to a religion and we are a secular state, and in a secular state, no, religion has nothing, no, the state has no religion. We have already discussed the idea of secularism initially, first class itself. So, because it relates to something that is of a secular state, a secular nature of the state, hence the state should not interfere in religious matters. And in this case, if you want to do that, what you should do is, you can increase the, as I said, meher ki rakam, you can make it 10 times, 100 times, but you should not criminalize triple talaq. Why? Because it is something that is it is something that is related to a particular religion. Clear? Have you understood this? Now, based on our understanding of Article 25 of the Constitution, can we say that triple talaq, or a law that has been enacted to prohibit triple talaq or making it a criminal offense, is it constitutional or not? Because we have the right to practice religion of one's choice, and if in this practice, if it permits the idea of triple talaq, or any such idea is permitted, any such provision is there, when the state comes out with a law criminalizing triple talaq, does it mean the state is tampering with religious practices? Does it mean the state is tampering with religious practices? Does the state have the right to do it? Or can we say that the state, by enacting such a law, has violated the secular principle? Why? Because morality factor comes into play. So, morality factor comes into play. So, what is the problem? If he is propagating this idea that you need to de-incentivize it, so de-incentivize it, make it 1,000 times. Is it a violation of the secular principle? Has the state taken up something which is unconstitutional by imposing or criminalizing triple talaq? No. Why? No to theek hai, aasan hai. My question is, till now what we have discussed, based on this discussion, what is the reason that you will give? Yes. In fact, there is not just one reason, there are three that I will give. What do you think is the reason why the state, when criminalizing triple talaq, has still not violated the secular principle? Why? Yes. बैठ के बोलो. Women rights have been violated. Constitutionally, this is correct. Okay. Anything else? This is not integral to a religion. Yes. Anything else? Against morality. Absolutely correct. Anything else that you can add here? She has actually given a very important idea here. Okay? She says that what practices that we can follow, as based on our discussion we already know that the Supreme Court says that the practices here means practices that are integral to a religion. Practices that are integral to a religion, or practices that are integral to a religious community, religion or a religious community. Now, can we say that triple talaq is an integral practice to this religion, to Islam? Answer is no. First thing is that the state has not violated secular principle. Why? Because this religious practice cannot be considered, or this practice cannot be considered integral to a particular religion. ठीक है? Second, read the first line that you have written. Subject to public order, morality, public health. After that, and other provisions of this part, which means if you look at the right to freedom of religion that we have, the right to freedom of religion is subject to other rights or other fundamental rights. So if right to religion or our religious practices that are there, if these religious practices go against the other fundamental rights that we have, like fundamental right to equality, if they contradict the other fundamental rights, fundamental right to equality, fundamental right under Article 21 of the Constitution, that is dignified living, in that case, such practices, even if they are integral to a religion, can be held to be unconstitutional, and the court, or for that matter the parliament or the executive, can prohibit such practices. Again, go through Article 25 clause 2 and go through exceptions. In exceptions, what you have written? In exceptions you have written first, regulating the second, providing for social welfare and reforms. Providing for social welfare and reforms, which means even if there is a practice that is going on which is being taken up in a religion, it can be prohibited on this ground as well, that there is some social reform that is initiated by the state. Now, some social reform has been initiated by the state, or in line of taking up social welfare. So those practices, first of all, can we say triple talaq is an integral practice? The answer to it will be no. Answer to it will be no. First thing is that. Second, the second idea that is there, the second idea is that can we say that these rights are absolute? No, because the Article 25 itself says that Article 25 is subject to other rights that we have under this particular act. So Article 14 of the Constitution, or for that matter Article 21, which talks about dignified living and right to equality, triple talaq may be a practice that is against the idea of equality and right to a dignified life. And thirdly, when we talk about the exceptions to Article 25, again, inherently within the exceptions to Article 25, it has been mentioned the state can take up certain practices or certain steps to initiate social reforms. Now, initiate social reforms, or for that matter take up social welfare. So now, can we say that when the state or when the government or the Parliament of India has enacted a law which prohibits triple talaq, now, or criminalizes triple talaq, can we say is it constitutional? Absolutely yes. Absolutely yes. The state has all the right to do this. The state has all the right to do this. Not just this. I'll give you another example, very interesting. Around 3 years ago, in 2016, there was a judgment of the Rajasthan High Court, and the judgment of the Rajasthan High Court banned a particular practice in Jainism. The practice was about fasting to death. Jainism has a practice there. And some sects in Jainism, they follow this idea that they fast to death. The way they tend to live life is that they will fast till the time they die. How did Chandragupta Maurya die? Chandragupta Maurya bhi aise hi mare the. He actually fasted unto death. No, he practiced Jainism basically, and he died in this manner. So Rajasthan High Court did what? Rajasthan High Court pronounced this as suicide, and because suicide is a punishable offence under the penal code that we follow, this particular practice was the particular practice was criminalized. It was appealed in the Supreme Court, and the Supreme Court took up a very different view on it. The Supreme Court said, no, we have the right to practice a religion of one's choice, and this can be considered as an integral practice there, and that is allowed, that is legal. So followers of Jainism, they have the right to fast to death. Why? Because this practice has been considered to be a part of their integral part of religion. And we have, as I've already said, who decides what practices are integral to a religion? It is the court which decides what practices are integral to a religion. So whenever it comes to certain aspects, like when it comes to public health, morality, or for that matter, public order, in that case, certain practices, even if it is integral to a religion, it is prohibited. The state can come up with laws for it. The state can come up with laws for it. Secondly, when we talk about the rights of the state to initiate social welfare, or for that matter social reforms, in pursuing the social welfare and reforms, the state can do what? The state can prohibit our rights or certain practices that are there, that we follow in our religion. Clear? Third, thus Article 25, the rights that it gives, or and for that matter, any rights that has been given to us under this fundamental right to freedom of religion, is also subject to other provisions, which means other rights that we have. So if we try and violate other rights, if we try and violate the rights, other fundamental rights that are given, that also cannot be done. And similarly, the state also, under the first exception, you can see it is said, regulating or restricting any economic, financial, political or other secular activities. So any practice that is there, that is taken up as a matter of religious practice, if we find that it is not something that is related to religion, rather it is a secular activity, in that case it can be considered as, the state can come up with certain prohibitions on it. The state can come up with certain prohibitions on it. इसका भी example देता हूँ. Generally you would find in Hinduism there is a practice of milk या जो दूध चढ़ाने का एक practice होता है. ठीक है, आपने देखा होगा. ठीक है, मंडे को बहुत लोग जो है वो शंकर भगवान के ऊपर चढ़ा रहे हैं, या इस तरह की चीज़ें होती हैं. It can be prohibited. It can be prohibited. Though it is a religious practice, we cannot deny that. But specifically when we talk about milk, now that is a secular activity. It has nothing to do with religion, and hence it can be prohibited. जैसे अगर मान लो इस तरह के practices हैं, फल चढ़ाना, ठीक है, if I am suppose taking up we tend to do this, we tend to come up with such practices, फल चढ़ाना, it can be regulated by the state. The state can prohibit it. Why? Because when we talk about fruit and this practice, it can be considered as a secular practice, not integral to a religion, and accordingly the state can prohibit it. Clear? Have you understood this? So remember, whenever we tend to, क्योंकि we tend to flaunt this idea a lot. ठीक है, अगर आप न्यूज़ डिबेट्स वगैरह सुनोगे ना, इसमें ये आइडिया बहुत फ्लॉन्ट होता है. We have the right to freedom of religion. You have the right to freedom of religion till the time the state wants you to enjoy this right. If the state actually prohibits it, there are n number of provisions in the constitution which allows the state to do it. And until unless you can prove that this is something that is integral to your religion, that practice can obviously be prohibited. बहुत सारे ऐसे cases हुए. 1950s we came up with something called as a Hindu code, and it prescribes for lot of provisions. Previously, again, this transfer of property rights that were there, it was not given to women. In Hinduism also, it was not given to women. In 1956, there was a Hindu code that was enacted, and through this particular code, reforms were introduced. The state has the right to do it. If you remember, we did talk about the nature of Indian secularism being different from the nature of Western secularism. And in Western secularism, you will find there is a wall. What did I say? There is a wall between state and religion, and the state will not interfere with religious practices on whatever grounds. The state does not interfere with religious practices. In India, that is not the case. Our secularism is wherein the state has retained the right to tell religion what to do. And you can see under Article 25 of the Constitution, though we are given rights to follow a religion of our choice, but it also explicitly deals with some certain provisions, the manner in which it has been brought into our Constitution. The state has retained the right to tell us what to do and what not to do. Clear? Understood this? You have to look at Article 25 of the Constitution along with Article 26 of the Constitution. They are similar rights. Article 25 of the Constitution provides every individual with such rights, whereas Article 26 of the Constitution provides rights to religious denominations, not just a single individual, but a religious denomination, a religious community, a religious group that is there. They enjoy certain rights under Article 26. But I'll come to it. Before that, you write this. Article 25, very important.
Sir, I have a question.
Yes.
If this is the case like we talked about triple talaq, so on what basis Supreme Court decides what practice is integral part of any religion? And second question is why there is any conflict between Sabrimala case about equality and secular? Because in that case, if we talk about the exception, the secular activities the women wants to share, it should come under that.
Women wants to share what?
Secular activities as well.
In Sabrimala case, you are talking. See, Sabrimala case, देखो, first of all, your first question is, let's look at it in this manner. Your first question is, what is the basis on which the court decides? ठीक है? The basis is determined by the court itself. That means there will be various arguments in the court, and in the argument, in that particular argument itself, if the court is satisfied that yes, this is something that is integral to a religious community, this practice, accordingly the court will decide that this is something that is a part of it. So what is the basis? It depends upon the kind of argument that you present. No, it is not arbitrary, because the court also uses some objective measures. Like, even in the Ayodhya case, while it was deciding on the prevalence of a mosque, that mosque is what is the concept of mosque? Like when it comes to, it was because it was about land and birthplace of Lord Ram, and it was considered that was the very birthplace of Lord Ram, and hence it was very integral to a particular community. On one hand, this argument was there. On the second hand, the argument was about when it comes to mosque, what is a mosque? So in that case, there was a judge of the Supreme Court who had written to one of the religious leaders I think in some other country. He asked him, what is the meaning of a mosque? And accordingly, he was actually written back that mosque is just like, the initial concept of mosque was just like an individual who is coming there, staying there and offering prayers. So it is not something that is integral, all these things. So the court also uses some objective measures to decide whether it is there or whether it is not. Now the second question that you ask is about Sabrimala. that whether Sabrimala case or when we look at triple talaq and when we look at Sabrimala, so what is the difference, and the right to equality, etc. See, first of all, the thing is that if you look at it from just purely from equality angle, in that case, right, on the basis of this right to equality, the Supreme Court can extend the rights to women to enter Sabrimala and offer prayers on the idea of right to equality. But if you look at the right to practice an integral part of religion, etc., that is there, in that case, if you go by the logical idea, what it dictates is that the deity that is located there, the deity had vowed for a kind of brahmacharya, not just any kind of brahmacharya, but a brahmacharya wherein even women were not allowed to touch him, and that was the very ground. So if you go by this angle, if you go by the specific nature of the deity, in that case, why cannot it be considered as an integral part of the manner in which the manner in which you are offering prayer? Here, when it is about the right of women to offer prayer or not, it is not just about equality. It is also about the manner in which that prayer is offered, whether it is being offered by women or not. Now, in this case, this is not something that is the manner in which the prayers are offered. This is not a secular exercise. Secular activities which are against women, like,
I mean, they also want to go and pray.
See, they want, देखो ऐसे तो मैं भी चाहता हूं कि मेरे पास 1000 करोड़ रुपए रहे, ठीक है, लेकिन when I have that right and I want that right, these are two different things. When I am exercising, मेरा तो मन ये है कि मैं जोर जोर से चिल्लाकर अपने रिलीजन की बात कहूं, लेकिन that is a violation of your fundamental right. You have a fundamental right to freedom of speech and expression, right to life. तो आप चाहते हो कि मैं रात में सोऊं, ठीक है, तो कोई बैंड बाजा और ये सब ना बजे, ये भी तो चाहते हो. So under Article 21 of the Constitution, right to life and right to life that is guaranteed to us, that is the reason, that may be the reason why I may be denied of some of my rights, because it encroaches upon your rights. ठीक है, तो आप इसे इस तरीके से भी तो देख सकते हो that deity, what is the nature of deity, and when women are offering prayer, it is not just about equality, and if it is about equality, the Supreme Court has the right to do that. But because Article 25 says subject to other provisions, so Article 20, it is always subject to other provisions, which means the Supreme Court can take simply this angle, that because it is subject to this and right to equality is one of the fundamental rights, so everyone has the right to pray. सीधी सी बात वो कर सकते हैं, उनको फिर और किसी चीज के अंदर जाने की जरूरत नहीं है. But when the Supreme Court, if the Supreme Court is deciding on this idea that whether women should have the right to pray or not, and whether it is a part of integral part of a religion or not, so in that case they will have to take into account the nature of the deity, and on that grounds it may not necessarily be a violation. Even if women are not denied, if women are being denied, it might not be considered as a violation of any other rights.
Then why only menstruating women, sir?
So वही तो बात है ना, that is the reason, that is the very reason, that is also one of the reasons that not all women are not allowed. Women only of a specific age, which also points out to the fact that it is about the deity that is there and the kind of vow that he has taken. That is the reason. When you are talking about religion and religious practices, so religion and religious practices is it is about a deity that whom you actually take up. बहुत सारे ऐसी चीजें होती है, you will find that there are number of practices that are there. So in that case, if you take that angle, you will have to understand the nature of the deity that is there. So it may not be considered as, it may be considered as an integral part of the religion, and thereby the court might deny that no, women are not allowed to pray. Lekin if the court takes that angle, subject to other provisions. In that case, simply looking at Article 14 of the Constitution, which guarantees equality, the court can extend that it guarantees equality, everyone has the right to. That's it. उसके अलावा कुछ करने की जरूरत नहीं है. But if you go into Article 25 and you look at it from Article 25, in that case, it may be when the court gives certain decisions like this, it may be, it may not necessarily be in the correct nature. Why? Because then that is interference of your religious practices. Clear? This is about Article 25. देखो, there is no one way to look at it. Simple सी बात ये है. There is no one way to look at it. There is no one way to look at it. If you go just by the phenomena of equality, you just go by equality, in that case, it simply says everyone has the right to equality, and hence they also, even women of a certain age also have the right to, they have the right to, worship. But if you go into the details, like, जैसे सुप्रीम कोर्ट ने जैनिज्म वाले केस में किया है, if Supreme Court goes into that kind of details, in that case, it is very likely that the Supreme Court will declare that such a practice, because it is an integral to a religion, it will continue. Clear? Have you understood this? Have you understood? See, the question is, now the question is about secularism. There was, if you go through this particular year's UPSC question paper, there was a question such, like this. So, if you look at that particular question, and if you look at Article 25 of the question of the Constitution, the provisions that I have talked about and the manner in which I have talked about, in that case you will be able to write an answer on it. Try it at your place. Okay, look at the question, just see the question whether you can write an answer or not. If not, I'll be discussing it again. Clear? Write this down. Article 25. Article 25 provides twofold rights to a citizen, that is freedom of conscience and freedom to profess, practice and propagate. Freedom to profess, practice and propagate a religion of one's choice. Religion of one's choice. Next paragraph. The freedom of conscience means the absolute inner freedom of an individual, to mold his religious beliefs and faith, and the state cannot interfere in this regard. The state cannot interfere in this regard. When this inner freedom, पागलों की कमी नहीं होती है, when this inner freedom takes an outward expression, it takes the form of right to profess, practice and propagate. Next paragraph. Right to profess means the right of an individual to express openly his religious belief and faith. The right to practice means right to follow rituals, right to follow rituals and put up signs and symbols, put up signs and symbols associated with one's religion, with one's religion. Right to propagate means right to spell out, right to spell out the tenets of one's religion, tenets of one's religion, TENANTS, tenets of one's religion, or the right to educate others, or the right to educate others. Therefore, the right to propagate includes, right to propagate includes the right to transmit and diffuse, transmit or diffuse a particular religious belief or practice, particular religious belief or practice. The Supreme Court in the state of MP, the state of MP versus Reverend Father Stanlisius, 1977 case, 1977 case has held that the right to propagate, the right to propagate does not include the right to convert others, the right to convert others, and any conversions have to be voluntary in nature, have to be voluntary in nature. The court has also made a distinction, between religious beliefs and opinions, and religious conduct and practices, The state can interfere, with religious beliefs and religious conduct and practices, on the grounds of public order, morality and health, Also, Article 25 clause 2 provides for exceptions, grounds of exceptions. Clear? Next, Article 26. See, though I generally do not give a lot of time to Article 25, why I have done this, the reason is you can always expect a question on it, like the question that was asked in 2019 about secularism and how our rituals and conduct or cultural aspects have interfered with it, or something like this. This is something that a question was asked. You can always expect a questions on it. Why? Because of the prevalence of this. Suddenly we have realized that there are a lot of practices which are against our fundamental rights, and they have been questioned from time to time, and that is the reason why you can get a question on it. Next, Article 26. Article 26. it deals with freedom of religious institutions, in brackets you can write religious denomination, and their right to the following, first, to establish and maintain institutions of religious and charitable purposes, second, to manage their own affairs, of religion, third, to own and acquire movable and immovable property, and fourth, to administer such property in accordance to law, administer such property in accordance to law. See, Article 25 and Article 26 of the Constitution, whatever rights that we have, when we say India under Article 25 to 28 provides us the fundamental right to freedom of religion. So what do we mean by freedom of religion, and what are the rights that are given to us? So not only do we have the rights, as individuals we enjoy the rights that are given to us under Article 25, conscience, propagate, practice and profess. As individuals we enjoy those rights, and as religious denominations, all religious denominations enjoy these four rights. So they have the right to establish institutions, maintain institutions for religious and charitable purposes. Every religious denomination has that particular right. No one can be deprived of that right. Secondly, we are also given the right as a religion or as a religious denomination, we have the right to do what? We have the right to manage our own affairs. So any matter that relates to a religion is managed by religion, not by the state. Third and fourth, the two rights that are there, it is about property rights. So not only do we have the right to acquire, every religious denomination having the right to acquire movable and immovable property, they also have the right to administer such property as they want, but it is in accordance to law. Clear? Now, first of all, the term religious denomination. What is meant by religious denomination? Religious denomination simply means a denomination or a group of people having common faith, common organization and designated by a distinctive name. You can write this. Religious denomination can be defined as a group having common faith, common organization and designation by a distinctive name, Clear? So three criteria. Supreme Court has come up with this criteria. There have been number of cases, and in subsequent cases, initially the Supreme Court just recognized religion in this manner, a religious denomination. Hindus, Christians, Muslims, Sikh. This was the religious denomination that was initially recognized. However, in later decisions, the Supreme Court says no. Within Hindus also there may be different sects or different groups, but the criteria is this: common faith. There should be common faith. Secondly, there should be common organization, and third, they should have a distinctive name or a distinctive nomenclature. So within Hindus also, there may be some sects or some groups that will have a distinctive name. So for them it will be different. Clear? So religious denomination means this. Second is when we say religious, managing their own affairs. What is meant by managing of their own affairs? The same idea that I talked about, that when it comes to affairs of a religion or matter that is related to a religion, it is to be seen whether a matter is an integral matter to the religion or not. If it is an integral matter to the religion, the state will not interfere. Otherwise, if it is not an integral matter, in that case the state can interfere. And in those matters, the religious denomination will decide by itself how to manage such affairs. So a religious denomination might decide that this is a particular deity, and what is the manner in which this practice is to be done, how this deity is to be worshipped. Now that is to be decided by the religious denomination itself. Clear? Like we did talk about, we were talking about Sabrimala case. So it may so happen that this is the argument, and it may be accepted by the court that yes. Why? Because it is something that has been given to every religious denomination. Clear? Second, the third and the fourth right that is there, it is with respect to what? It is with respect to right to own or acquire movable and immovable property, and right to administer that property. It can be done. They can acquire movable and immovable property, and they can administer a property of their, the manner in which they want, but in accordance to law. Law should not be violated. Because Article 26 is like a complementary right under freedom of religion and freedom of religion that we have, like 25 giving it to citizens, this Article 26 of the Constitution is also under the same kind of restrictions that is Article 25 is under, which means Article 25 says morality, decency, public order. So they are also subject to morality, decency and public order. So I cannot in way of managing my own religious practices, I cannot disturb public order. I cannot disturb public order. You must have heard about an individual, बहुत सारे लोग हैं और कुछ की बात करते हैं, बाबा राम रहीम. क्या है वो? That is basically this. No, you have the right to manage. You have the right to manage your affairs, and the state does not interfere, but it should be subject to law. You cannot start violating law in the name of managing your own affairs. Managing your own affairs. So you cannot do something like that. Or for that matter, there is another recent example. Not recent, but there was a case that was continuing for the last 3 to 4 years. उसका एक decision हुआ अभी. Baba Rampal. He was convicted of murder very recently. It was in the state of Haryana, I think Hisar district or somewhere. उसमें क्या हुआ था? He was, he had an institution. He was जिस तरीके God claim करते हैं, Godman है, etc., etc. So he had an institution. He continued with that. Absolutely fine. So what happened was that there were certain farmers who started claiming, क्योंकि उनका land जो था वो उस institution के आसपास था, they started claiming that when we go to take up any kind of activities on our land, they tend to fire on us. You are violating law. After this complaint became prevalent, then there was a police action that was taken up against that particular institution, and it took police 2 days to catch him within that particular institution. 2 दिन लगा पुलिस को. and he was right now very recently he was convicted of murder. देखो, you can as a religious institution you can manage your, because it is according to the definition it can be described as, जैसे हम डेरा सच्चा सौदा की बात करते हैं, it can be described as a religious denomination. Yes. Why? Because three criterias: common faith, yes; common organization, yes; do they have a distinctive name? Yes. So they can be described as a religious denomination. But do you have the right to in any way disturb public order, morality or decency? No, you don't. So if you look at Article 25 and Article 26, Article 26 is also subject to morality, decency and public order. Clear? Article 25 and Article 26 are not different. Just think of it in this manner. Article 25 are individual rights, Article 26 are group rights. So as a religious denomination we enjoy these rights. Clear? Next, Article 27. Again, this is again a very important article. Article 27. Article 27 says what? First write, then I'll explain. What is the, don't just start writing Article 21, just write the heading of it for now. Freedom as to payment of taxes. Freedom as to payment of taxes for promotion of any particular religion. For promotion of any particular religion. Article 27 of the Constitution. Article 27 of the Constitution says what? It simply says, because you have just written the heading of it, it says freedom as to payment of taxes for promotion of any particular religion, which means the state cannot force me as an individual, as a citizen, to pay tax, and the proceeds of the tax is used by the state to promote a religion, a particular religious denomination or a particular religion. It cannot be done. It cannot be done. Now, effectively it simply means that, see, there are two mechanisms through which the state collects revenue. The most important mechanism obviously is tax, and whatever money we actually pay as tax, that money becomes the part of public money. It becomes a part of a public fund, and the fund that is there, it is used for general welfare. It is never used for a particular community or a particular religion or a particular group. No, it is used for general welfare. Now I cannot say that, suppose I have paid income tax, so I cannot say that this tax is being used for a particular purpose. No, there are so many individuals who are paying taxes. All of those taxes become a part of a common fund. ठीक है, ऐसा नहीं होता कि one fund is used for a specific purpose. No, all of those taxes become a part of a common fund, and this common fund that is there, it is utilized for what? This common fund is utilized for general welfare of the people. So Article 27 of the Constitution prohibits that such a tax, such a payment that is there of a tax cannot be used for a particular religion. For a particular religion, the state can use the proceeds of tax, but state can use the proceeds of tax. Even the state can use the proceeds of the tax to promote religion, but provided it is used for all religion, not a particular religion. Secular nature of the state. So if the state uses funds to promote a particular religion, what happens? What are we trying to do? We are actually violating what? We are actually violating the secular principle. The state, तो फिर आप secular किस नाम के? When you are promoting one religion, you are not a secular state. And Article 27 of the Constitution talks about that. Article 27 of the Constitution does not prohibit, though it prohibits use of taxation money, but it does not prohibit the use of fee. It says taxation are not allowed, fees is allowed. What is the difference between tax and fee? What is the difference between tax and fee? Is there a difference? Yes, what is it? क्या है?
Tax is for general use, fees is for specific.
Fees is for specific. Do you think this is the only difference? This is the main difference? देखो, tax. No, you. Yes, हाँ. क्या कह रहे हो? हाँ. And fee? Absolutely correct. This is the difference between tax and fee. When you impose tax, it is not discriminatory in nature. It is imposed on all, used for general purpose. Whereas when it comes to fee is levied only against those individuals who utilize a certain service. So I pay fee for suppose I have to get an voter ID. So when I go there, I will have to pay a fee, 25 rupees, something like that. So I have paid a fee and I will pay that fee. Is it indiscriminately levied? No. Only those individuals who want a voter ID will have to pay for that voter ID. Clear? So fee is of that particular nature. Actually, both of these, tax and fee, they are ways in which the state collects money. The only difference is, when we talk about tax does not have something called as quid pro quo, whereas fee has something called as quid pro quo. Quid pro quo means I do something for you, you do something for me in return. Fee has this particular idea that I am paying fee for a particular reason. So I am paying fee to the state will give me this in return of that particular fee. Quid pro quo. It is something called as quid pro quo. I do something for you, you do something for me. I scratch your back, you scratch mine. Okay? Quid pro quo. That is what is the meaning of quid pro quo. I do something for you, you do something in return. Clear? So fee involves this idea of quid pro quo. That is not the case for tax. That is not the case for tax. The amount of money that is paid in form of taxes is generally used for the weaker section of the society. But weaker section is not paying tax. Weaker section is not being paid, they are not paying tax. Suppose members below poverty line, how can they pay tax? Or members who are suppose below a certain criteria in terms of income, they are not paying tax. But the money is being utilized for them. So there is no such thing as quid pro quo. We say general welfare. Clear? So the money that I have paid as tax cannot be utilized by the state. It cannot be utilized by the state for promoting a particular religion. Promoting a particular religion. Interestingly, the Constitution does not prohibit that you will not use money for not promoting all religion. What Constitution prohibits is the state will not use the proceeds of taxes to promote a particular religion. They can use it for promotion of any religion or all religion. When all religion are being promoted, in that case there is no problem with the use of such a money. General welfare. Again, the idea is what? General. It's not that one specific group derives benefit out of that particular tax. We just said tax is for general welfare, for use of everyone, not just for some. It is used for everyone. I am paying tax. In return of it, I may get a good infrastructure. Someone is getting some welfare someone is getting welfare policies. For them, those policies are being implemented. I am paying tax. My concerns are different. What is the state offering me? The state is offering me infrastructure. The state is offering me, mechanisms to travel. The state is offering me better services, etc., etc. General welfare. Sabka bhala ho raha hai. Clear? Religion, proceeds of such tax cannot be utilized for what? The proceeds of tax cannot be utilized for promotion of any particular religion. There is no such prohibition to use it for welfare of or promotion of all religion. It can be done. Now, this is what technically it means. But if you look at the qualitative idea behind Article 27, the qualitative idea behind Article 27 is that Article 27, it is Article 27 of the Constitution which actually, what you can say, it actually gives us or gives us an analysis of what kind of secularism India has. And India follows a philosophy. What is the kind of our secular philosophy or philosophy of our secularism? It is about Sarv Dharm Sambhav. All religion is possible. Why? Because the state may help a religious community provided it is helping all religious communities. The state, it means the state does not discriminate among citizens, or the state does not classify citizens on the basis of religion. We are not given, we are all citizens of a particular country, India, a secular country called as India. And in India, we do not classify citizens into class 1, class 2, class 3, class 4 on the basis of religion. Every citizen has similar rights. Whether you are belonging, you may belong to different religion, or you may not be, you may completely give up religion. The state has nothing to do with it. The state will not classify you as grade 1 citizen or grade 2 citizen, providing grade 1 citizen more rights and grade 2 citizens less rights. If the state is allowed to use taxation money for promotion of one religion, what does that mean? It means that the state might use this to promote one religion, allowing one religion to have more rights over others, promoting one religion over others. But that is not the case. That is prohibited under the Indian Constitution, which shows that in India, we are a secular state. In India, every religion is possible. Every religion is possible. We as a state, we do not have a religion. State does not have an official religion. It does not mean the state is irreligious. Okay, that is, the state is not antagonistic to any religion. ये भी बात है. Secular state का मतलब ये नहीं है that we are, the state does not recognize any religion and becomes irreligious. No, the state does not have an official religion. It means the state is only non-religious. The state is not irreligious. It is not antagonistic to the interest of a particular religious community. It is not antagonistic to the interest of a particular religious community. But we do not promote one religion over other as well. We do not classify or discriminate among citizens on the basis of religion as well. मतलब सीधा सीधा ये है. Post independence we realized. Post independence the constitution makers realized that this is not the time, or it will never be a time wherein we would classify citizens, or the importance of classifying the state as having a particular religion. अगर post independence आप देखते हैं, India could have accepted Hinduism as a official religion, because more than 80% of the individuals were Hindus. Even today they are Hindus. But that was not done. Why? Because we prioritized. This is not the priority. The priority is development. The priority is prosperity. Prosperity होना चाहिए, development होना चाहिए. It is not about religion, whether the state has a religion or not. If we further do that, we are classifying citizens into on the basis of religion, which may be wrong, but it is done. Now in India, if you look at across the world, there are number of states which have declared themselves as Islamic states. The state has a religion, Islam. Pakistan is an example. Pakistan is an example. Previously, Pakistan was a secular state. If you look at the initial constitution of Pakistan, it was a secular state. But Zulfikar Ali Bhutto is considered to be an individual who laid the foundations of Islamic State of Pakistan. And later on, Zia-ul Haq, who was the dictator of Pakistan after Bhutto, he basically ensured that Pakistan turns into an Islamic state. Zia-ul Haq, देखो ऐसे तो आप भुट्टोस के बारे में जानते होगे और आपने सुना होगा बहुत प्रोग्रेसिव माइंडसेट के हैं, लेकिन जुल्फिकार अली भुट्टो was the individual who actually laid the foundations of Pakistan becoming an Islamic state. And it was for his personal gain. It was for his personal gain. During the 60s, he understood that, see, because I did not join NAM then, and I became an ally of US. What has happened is suddenly when you look at the world scenario, the idea of liberalism, the idea of anti-racism, etc., this ideology has been captured by an institution of NAM. And Jawaharlal Nehru was one of the leaders there. So Jawaharlal Nehru, in the 1950s itself, he got that kind of stature. Despite the fact that India was an underdeveloped country, but in terms of political leadership, adopting democracy, joining non-alignment, all of this gave Jawaharlal Nehru a certain position when it came to the international arena. That position was not something that was shared by Pakistan. So he understood that there is only one case in which I could be recognized as, in the same column as individuals such as Jawaharlal Nehru, if I become the leader of Islamic world. Rather than being the leader of a particular country, if I become a leader of a Islamic country. And this is what he did. From there, the roots of this idea of Islamic State was laid, and later on Zia-ul Haq did that. Zia-ul Haq, he was a fanatic with respect to this idea, and he changed a lot of laws, etc. there. So there are countries around the world, to be very specific, there are 53 to 54 countries in the world who recognize that they have an official religion. India does not. Why? We are a secular state. What is the philosophy behind it? We do not discriminate against citizens on the basis of religion. It is contrary to our our constitutional philosophy. How can equality and state having religion how can it go together? It can never. The idea of equality says everyone is equal in the eyes of law. It does not matter if you belong to a particular religion or not. Equality prohibits any kind of discrimination, and that discrimination may be on the grounds of religion as well. And as you all know, in the Ayodhya verdict and before that also, the Supreme Court has declared that religion is a private matter. It is something that is a private matter. India is a secular state, and in a secular state, it is the basic structure of our constitution. No government, no political party coming to power can ever change this provision until unless we have an independent, till the time we have an independent judiciary. And this very idea is mentioned, qualitatively mentioned under Article 27 of the Constitution. And this is how our secularism is different from the secularism of the West, wherein West fails to recognize religion. We do not fail to recognize religion. We recognize, yes, religion hai, different religion hai. What we do is we do not discriminate among religion. We do not fail to realize, we do not fail to recognize religion. Sarv Dharm Sambhav. The philosophy of Sarv Dharm Sambhav. This is what India's secularism is, and that is what has been mentioned under Article 27. Clear? Yes. देखो, Supreme Court can allow to do this. See, Supreme Court has not allowed to build a temple. उसका भी देखो एक technical reason है. थोड़ा सा इस बात को समझना पड़ेगा. Absolutely right. When the Supreme Court has given this judgment, let's understand what this judgment is about. देखो, in the Ayodhya verdict, there were number of litigants. One of the litigant was Ram Lalla. That means it is the childhood form of Ram, and that under the Ayodhya verdict has been recognized as a legal entity. Because it has been recognized as the legal entity, it is a fictional legal entity. So if Ram Lalla is not, it has been given that particular land, but it is a fictional legal entity. So if he is not going to build the temple, who has this right? If it is not his, whose land it is and whose right it is? It is the state's land and the state's right. And accordingly, the state has been ordered by the Supreme Court to do this. देखो, there is also something called as Article 142 of the Constitution. Article 142 of the Constitution empowers the Supreme Court to do complete justice. It empowers the Supreme Court to do complete justice. तो ये भी है ना, देखो 5 एकड़ लैंड देने की बात की गई ना, that वक्फ बोर्ड should be given 5 एकड़ लैंड और वहां पर वो मॉस्क बनाएंगे. बात यह है कि सुप्रीम कोर्ट क्यों ऐसा कह रहा है? The dispute is a civil dispute. It is about whether this land belongs to whom, and accordingly the decision should be taken that this land belongs to this individual and not this individual. But the Supreme Court has said 5 एकड़ land do. Why? So that complete justice is done. No party, because of the nature of dispute was such, no party is derived of or deprived of any rights. इस वजह से किया गया. So can the Supreme Court order any such thing? Yes, they can, legally speaking. In fact, there are lot of exceptions. अगर आप देखोगे तो the Constitution of India prohibits use of tax money, लेकिन हज subsidies मिलते हैं. सुप्रीम कोर्ट में अपील भी किया गया है. Isn't this violative of secular principle? Supreme Court says no. Supreme Court का कहना यह है that if the amount that is given from taxable money, if it is insignificant, it is not violation of it. Going back around 1990s में, there was a case in which the government of India was celebrating a Jain festival because of it was a landmark festival or something like that, and it talked about building it talked about a grand celebration or something like that. It was challenged that how can the state do? State is a secular state. The Supreme Court said celebrating such things, if you look at the exact judgment, rejecting the contention of the petitioner, the court held that when you celebrate a distinguished person who has contributed to India's cultural heritage, that kind of it cannot be considered as a violation of Article 27. Going back, there was a law that was enacted, Odisha Hindu Religious Endowments Act 1939. तब तक तो ठीक था, लेकिन is it contradictory to Article 13? Because fundamental right is there and secular nature, but the court says that it is absolutely fine. There is no problem. Why? Because the fee that is there, this talked about that the concerned board that is there, that will pay 250 rupees to the commissioner and some employees. This law talked about that. Commissioner and some employees who will be taking up audit, etc. of the accounts. The court said it is absolutely fine. It is absolutely fine. Jaldi. Not a tax, this is a fee. So under various interpretations, the court allows for some kind of exceptions to this this principle. What you need to understand is the idea is that it should not become a rigid rule as well. It should not become a rigid rule as well, because state has certain responsibilities and duties. And if the state does not take up certain responsibilities and duties, it might have a spillover effect. It might have a spillover effect. So if the state is not given, in this case the responsibility has nature ये है, न्यूज़पेपर में मत जाओ, मैं जो बताता हूँ वो सुनो. वो ये कहा गया है that there has been a 3-month time period, 90 days, that has been given to the state. The Supreme Court has said that the government should come out or chalk out with a plan to build a temple, not the responsibility to build the temple. पहली बात तो ये है. बट ठीक है, फिर भी द स्टेट कैन डू दैट, क्योंकि स्पिल ओवर इफेक्ट होगा. कल को आप क्या चाहोगे कि अगर स्टेट ये काम नहीं करेगा तो कौन करेगा? स्टेट ये काम नहीं करेंगे तो चलो वो जो है क्या कहते हैं, जिन्होंने टेम्पल तोड़ा था वो काम करेंगे, ये जिन्होंने मॉस्क तोड़ा था. फिर आप सोचो कम्युनल वायलेंस के कितने चांसेस हैं. ठीक है. सो व्हेन वी टॉक अबाउट एनी सच स्टेप, any such direction that is given by the court, you need to understand that it is not like a fixed rigid rule. It is applied to a situation. It depends upon the situation. Why? Because whenever we talk about the responsibilities that the state has, these responsibilities may have a spillover effect. So building a temple is important, because otherwise it may so happen that it may lead to some communal violence. So law and order maintenance is the responsibility of the state. Similarly, so the court will say not only build the temple, even build the mosque. ठीक है, क्या problem है? Clear? So this is something that is done. It is not applied with complete rigidness. There is, every rule has an exception, and this is what is done as well. Some exceptions are allowed. The court tends to, from various accounts, and in various cases it interprets it based on what the situation dictates. And that is the reason why Article 27 remains relevant. Otherwise it becomes irrelevant. फिर तो ये डिमांड होगा इसको अमेंड करो, खत्म करो इसको. ठीक है. अदरवाइज फिर ये भी होगा कि जब दुर्गा पूजा दशहरा होता है तो पुलिस क्यों खड़ी है? स्टेट कर रहा है ना, क्यों प्रमोट कर रहे हो रिलीजन? ये भी बात शुरू हो जाएगी. स्टेट वाई इज द स्टेट डूइंग दिस? बिकॉज आप देखोगे ऐसे ही यहाँ पे जो सावन का टाइम आता है, कावड़िया रहते हैं तो ऐसे ही हो हंगामा करते रहते हैं. अगर स्टेट की रिस्पॉन्सिबिलिटी नहीं होगी, स्टेट डज नॉट प्रोवाइड फॉर कि चलो यहाँ पर रहने का जगह बना देते हैं या कुछ इस तरह का कर देते हैं, व्हाट विल हैपन? इट हैज सम स्पिल ओवर इफेक्ट्स. सो यू कैन नॉट अप्लाई इट एज अ रिजिड रूल. बट येस, the principles on which it is applied, it should be similar in all cases. Rigid rule की तरह नहीं, लेकिन principles similar होने चाहिए. Clear? Have you understood why Article 27 of the Constitution talks about the nature of Indian secularism? It prohibits the state from promoting, using the proceeds of taxation to promote one religion over other. Clear? Write this down. Article 27. It says, no person shall be compelled to pay any tax the proceeds of which is spent to promote a particular religion and religious denomination. Article 27 truly spells out the secular character of the state. Secularism means that the state is neutral. On religious affairs. The state regards religion as a private affair of individuals, private affair of individuals. It does not interfere, it does not interfere with religious beliefs and opinions. Next paragraph. Religious beliefs and opinions. A secular state is not opposed to religion. Is not opposed to religion. It is non-religious in character. Non-religious in character, not irreligious, or anti-religious, The Western secularism separates religion from the church, and the state does not patronize. The state does not patronize and support any religion. Indian secularism recognizes the need for religious pluralism and recognition of rights of all religion that have made India their home, and the right to coexist on the soil of India. It is based on the philosophy of Sarv Dharm Sambhav. Which does not prohibit the state from promoting religion, provided no discrimination is shown. Further, Article 27 does not prohibit the fee collected by the state from spending it for the benefit of a religion. Clear? So obviously there is no limitations on the fee. But there is obviously limitations on proceeds of taxes. Clear? Absolutely clear. This is Article 27 of the Constitution. Okay? देखो, what you would find is, if you try and derive the knowledge of India's secularism from these things like newspapers or from TV channels, in the frequent debate that is there, they tend to partially present what India's secularism is about. Newspapers, they tend to, like the Hindu, it will always write against the government. Okay? It is, it has that leftist orientation. There is no denial to that. So their idea of what they want secularism is what they are presenting. It is not what Indian secularism is. Similarly, if you look at news channels, News channels, no, they are going to talk about secularism. The anchors, and they are talking about secularism about what they think India's secularism is. But India's secularism is a bit different. Okay? It is about recognition of all religion. It is about coexistence of all religion, and it is about helping all religion. It is not about helping no one. Generally ये होता है that helping no one. Why is the state doing? No. It's not. The question should not be why is the state doing this. The question should be why, is the state helping religion with equality? That is the question. If that is what the state is doing, there is no question about the nature of India's secularism, because that is what India's secularism is about. That is what India's secularism is about. So you will find, there are number of questions that come up, like this example that is there, that during जैसे कावड़ियों के टाइम पे इस तरह की जो चीजें होती है, see the state is spending some insignificant amount for that, but in return what is the state guaranteeing? Law and order. The state is guaranteeing law and order, ensuring that there is no such thing as disruption of law and order, or for that matter disruption of health, public health or public morality. That is what the state is guaranteeing. So there is no problem with such ideas. There is no problem with such ideas. If suppose the state provides for Hajj subsidies, or previously it used to do that, there is no problem with this. Why? Because the court has said that this is not, it is not something that is violating the secular principle. Why? Because the amount is insignificant. It's a very small amount, the subsidies that are given. Absolutely fine. What is the problem with that? There should be, there should not be. Political parties tend to use it for political benefits. We have to understand the true nature of it. The true nature of it is that when it comes to taxation, money is not to be used, but it does not prohibit the state from helping all religion. It does not mean the state is prohibited completely from helping religion and religious communities or something like that. No, that is not there. Clear? Next, last article under freedom of religion, that is Article 28 of the Constitution. Article 28. You can write, it's just factual, you have to learn it. It deals with freedom as to attendance at religious instructions or religious worship in certain educational institutions. So can I be forced to attend? If suppose I am attending an educational institution, can I be forced to attend religious instructions or religious worship? Can it be done or not? नहीं, ये आंसर सही नहीं है कि नो, हर जगह नो नहीं होता. It is actually, it depends upon the nature of educational institution. If the educational institution is run by the state or receives aid out of state money in terms of recognition that it has, in that case religious instructions cannot be imparted. कर ही नहीं सकते हो. But if the state is only administered by the educational institution is only recognized by the state, not administered by it, religious instructions can be imparted, but individuals are free. You want to attend, fine. Don't want to attend, that is also fine. However, if there is an educational institution that is established by a community, like we have talked about religious denominations having rights to establish religious institutions for charitable purposes or for educational purposes. If that is a religious institution and there you are being imparted education there, in that case not only can they have the right to impart educational religious instructions and worship, you can also be forced to attend it. Clear? So it's not, this is not something that is the universal idea that no, I cannot be forced, you can be. Okay? If you have studied in suppose any kind of मिशनरी स्कूल्स वगैरह, ठीक है, अगर मिशनरी स्कूल के प्रोडक्ट हो तो आपको ये पता रहेगा कि हमें वहाँ पर, ठीक है, प्रेयर सिखाया जाता था और हम प्रेयर्स बोलते थे. इट इज़ नॉट अनकॉन्स्टिट्यूशनल. वाई? डिस्पाइट द फैक्ट दैट इट इज समथिंग दैट it is not in accordance to what my religion is, what how we tend to prayer, what our practices are, but still it is something that is constitutional because that is a missionary institution. It has been established by a charitable or a religious institution for educational and charitable purposes, and hence it is absolutely constitutional to do it. But when it comes to any institution that is that is run by the state, like केंद्र विद्यालय, KVs and इस तरह के जो organizations होते हैं, you cannot impart religious instructions there. There can be no religious worship that can be taken up there. Clear? So these things are there. उस समय खैर कोई किसी को क्या पता होता है, सब करते हैं, but it does not matter. It should not matter also. But thing is that if you look at true nature of the state, if the state is truly of secular nature, in that case such institutions or in such institutions which are run by the state, religious instruction should not be imparted if the state is of true secular nature. That is what the constitution mentions. Clear? Write down. Educational institutions, next paragraph, start with next paragraph. Educational institutions that are owned by the state, no religious instruction whatsoever can be imparted. Educational institutions that receive aid out of state fund, and are recognized by the state, religious instructions can be imparted. But the students cannot be compelled to attend. Such religious instructions. In case of educational institutions that are administered by the state, but have been established by religious endowments or charitable trust. Religious instructions can be imparted. And students can be compelled to attend such instructions. With this, we complete our discussion on Article 28. We also complete the fundamental right to freedom of religion. Next fundamental right is educational and cultural rights. So the fifth fundamental right, we are basically discussing the fifth fundamental right, educational and cultural rights. First article, Article 29. Article 29. Very important. What is the title of it? Write down. Protection of interest of minorities. Title of it is Protection of Interest of Minorities. Interest of minorities. Article 29 clause 1. Any section of the citizens residing in the territory of India having a distinct language, script or culture of its own shall have the right to conserve the same. Clear? Underline any section. Also underline language, script or culture. Underline that. Next, Article 29 clause 2. No citizen shall be denied admissions into any educational institution maintained by the state or receiving aid out of state's fund on grounds only of religion, race, caste, language or any of them. Clear? So if you look at Article 29 of the Constitution, what is the heading of title of Article 29? It says rights of minorities. But interestingly, Article 29 does not talk about minorities. Though the title is rights of minorities, but if you see Article 20 clause 1, it says any section, not necessarily minorities. Yes, if you look at it from this angle, that yes, because it talks about any section, so rights of minorities are included. Now that is a different thing altogether. But otherwise, if you look at rights of Article 29, it specifically does not mention that this is a right that is only enjoyed by minorities. Clear? Only enjoyed by minorities. Further, Article 29 of, no need to write, just if you look at Article 29 of the Constitution does not mention any idea of minorities. It does not define also what is minorities, or it does not say any section of the population or any section of the individual residing in India who fall within the definition of minority. No, it says any section of the population residing in India, which means any individual, any citizen who is residing in India, though they belong to minority or not, it does not matter. If they have a distinct language, a distinct script, or for that matter a distinct culture, they have the right to protect that particular culture. Clear? Similarly, Article 29 clause 2 says what? That no individual or citizen shall be denied admission in any educational institution maintained by the state or receiving aid out of state fund. on the grounds of religion, race, caste, language, or any one of them. Clear? So religion, race, caste, language, or any one of them. What is the difference between Article 15 and Article 29? Article 29 of the Constitution also talks about no discrimination. Article 15 also talks about no discrimination. So what is the difference? Article 15 clause 2, no, Article 15 clause 2 was not just about it was not just about it was against individual. It was about access to public places. I am talking about Article 15 clause 1, not about 15 clause 2. Article 15 clause 1 says what? Yes, state cannot discriminate. What are the grounds that are mentioned? Place of birth. See, race, religion, caste, place of birth. Sex, place of birth. Clear? Now if you look at the grounds here, you can see the difference. Here, religion, race, caste, sex has not been mentioned. Secondly, language. Language is being considered that this cannot be the ground for discrimination. When it comes to admission to educational institutions, sex can be a ground for discrimination. Obviously, it is a ground for discrimination. तो मैं ये नहीं जाके बोल सकता हूँ कि नो चलो कि आप जो है अगर नो मैं गर्ल्स कॉलेज में चला जाऊँ और बोलो कि देखो नहीं मुझे एडमिशन चाहिए. ये फंडामेंटल राइट है, राइट. देयर शुड बी इक्वालिटी एंड देयर शुड बी नो डिस्क्रिमिनेशन. दैट इज अ ग्राउंड. देखो यहाँ पे लिखा हुआ है ना, sex has not been mentioned here, which means sex is a ground for discrimination. ठीक है? Here even place of birth has not been mentioned, which means place of birth can also be a ground for discrimination, when not for everything, only for educational institutions. That means when it comes to admission in educational institutions. So place of birth can also be a ground for discrimination. If you remember, going back to our earlier discussion of Article 15, we did talk about scheduled areas. We did talk about scheduled areas. We said that in scheduled areas, when educational institutions, admissions in educational institutions are there, in that case, in scheduled areas, that reservation that is applied for other backward classes, that is not applied in scheduled areas. Why? Place of birth. Place of birth can also be a ground for discrimination. Clear? It can also be a ground for discrimination. Clear? But language cannot. So you cannot deprive me or deny me of a right or to get admission in an educational institution which is either receiving aid out of state fund or an educational institution that is run by the state. In that case, this cannot be. These four grounds, religion, race, caste and language, cannot be the ground for discrimination. Okay? But here again, the term only has been mentioned. So underline that, only, which means what? There can be additional grounds for discrimination. There can be additional grounds for discrimination. Clear? So Article 29 of the Constitution, certain technical things that you need to understand. First, Article 29 of the Constitution, though is titled Protection of Rights or Interest of Minorities, but it provides rights or interest not to just minorities, but it also protects the right of any section of the individuals residing in the territory of India, having a distinct language script or having a distinct culture. Clear? Now, there was a case that happened, interestingly, it was in the year 1965. In the year 1965, in a particular case called as Jaidev Singh Siddhant versus Pratap Singh Daulata case, what had happened was these two individuals were contesting elections for the position of MP. And one of the individuals, that is Pratap Singh Daulata, that was there, he used a particular flag for campaigning in his election. and the flag was Om Dhwaj. Okay, it was written Om and there was a flag that was there. In that particular flag, and in that particular flag that was used, and his campaign basically, because it was in the state of Punjab, so he was campaigning, his campaign revolved around Hindus, that how they were minorities there in that particular region, because we are talking about the state of Punjab, and how their rights should be protected, and how he was the one who was, if he gets elected, he is to protect that particular rights. Clear? Elections were conducted and he won the elections. Pratap Singh Daulata wins elections. Under section 123, clause 3 and clause 3A of Representation of People's Act, hate speeches are basically considered as a punishable offence, and if it is found that you have done any such thing, you are ineligible. Even if you win the elections, you can be disqualified. So the other individual, that is Jaidev Singh Siddhant, that was there, he contests this in the Punjab High Court, saying that, see, this is a violation of section 123 of the Representation of People's Act, because he has used Om Dhwaj and he has talked about Hindus. The Punjab and Haryana High Court upholds it and disqualifies Pratap Singh Daulata, who in turn questions this judgment in the Supreme Court. The Supreme Court interprets Article 29 and says section 123 of the section 123 of the Representation of People's Act is subject to Article 29, which means it is below Article 29, and Article 29 of the Constitution confers every citizen the power or the authority to conserve a distinct language, script or a culture, language, script or culture, and thereby says that this is not the ground for disqualification. What he has done is not a violation of section 123. Why it is not a violation? Because it has, there is a fundamental right under Article 29 which gives us the right to protect our language, script as well as culture. So if he is talking about Hindus, so there is nothing wrong with it. Or when he is using Om Dhwaj, it cannot be considered as a hate speech. Or when he is talking about protection of rights, he is not talking about, he is not talking about this ground that, Hindus should vote against a particular community or something like that. So because he is not talking about that particular ground, and he is talking about interest of, a particular culture, talking about some kind of culture. He was talking about basically language, Hindi language. So when he was talking about Hindi language and such things, it is absolutely constitutional. Why? Because it cannot be under section 123. Why? Because Article 29 provides us the fundamental right to do it. Interestingly, in that particular decision, the Supreme Court also said that Article 29 is not subject to reasonable restriction. Article 29 is not subject to reasonable restriction, which means to protect your language, your script and your culture, whatever you do is considered to be constitutional. Even if you agitate, you take up agitation, you take up any kind of steps, it is considered to be constitutional. ये 1960s का केस था और ये लास्ट डिसीजन है सुप्रीम कोर्ट का. That means since then, if you look at the interpretation of it, then interpretation means that to protect my language, to protect my script or to protect my culture, if I take up any action to conserve it, it is constitutional. There is no reasonable restrictions imposed on it. Till now, what have we been talking about? Fundamental rights are under reasonable restrictions. Supreme Court declares Article 29 is not under reasonable restriction. But what is it? I'll be talking about in the next class. ठीक है? उस समय I'll be dealing with this again. Don't worry. ठीक है? Thank you.